Vikki Slade. Madam Deputy Speaker, and thank you to the last speaker for schooling me in maths. I'm not very good at that. I'd like to begin by expressing my strong support for the overall Children's Welfare in Schools Bill, particularly its efforts to enhance child protection and ensure better collaboration between professionals in children's social care. And I welcome measures in Part 2 which seek to harmonise admissions and provide support for the cost of living for families, especially those from deprived backgrounds. Parents whose children are in state-funded education deserve transparency. They should have access to clear information about their child's education and be assured that the schools and trusts are operating fairly. And I look forward to the areas not in this bill coming forward that are really going to make the difference for children, such as the child poverty strategy, the SEND review and the curriculum review. But there is one part of this bill that I believe needs to be amended, and that is the level of scrutiny, unnecessary scrutiny, that's being imposed on parents to choose to home educate their children. Rather than protecting them, elements of this proposed register risks putting these families in danger. Let me be clear, I support the principle of the register. Local authorities, as corporate parents, need to know where children are if they're not attending school. Collecting some information and the reasons for elective home education is important, not only for child protection, but also so authorities can plan for the future. We know that some children who are home educated later return to school, and many parents make this choice because the local education provision does not meet their child's needs, either temporarily or permanently. This presents an opportunity for local authorities and multi-academy trusts to work collaboratively with those families to ensure that curricula and school offerings are inclusive of their needs. But Section 436C, which governs the content and maintenance of the Home Education Register, contains provision that could have serious unintended safeguarding consequences, as already suggested by the Honourable Member from Sheffield Central. Under Clause 25, Section 434A, the local authority must serve notice to both parents unless exceptional circumstances apply. For instance, Madam Deputy Speaker, in cases of domestic abuse or family estrangement. Yet Section 436C under Clause 26 requires the register to include the name and home address of the child, both parents' names and addresses, and the addresses of all places where education takes place. Crucially, there is no provision for exceptions in cases where sharing this information could put children at risk. One of my constituents, whose name I will protect for obvious reasons, told me, "Since 2018, I have managed to keep my home address private from my ex-partner. Throughout the court case, I was supported to keep my address private, and it was never included in any document he would have access to. This register will hand him our home address, details of my new relationship, the names and addresses of my new partner's parents who will support me. It will hand them the address of every activity my child attends. This proposed register essentially hands him motivation, evidence, licence and opportunity to continue his coercive controlling behaviour. Currently," she goes on to say, "we are safe. My daughter is known in the home education community. She is not hidden. She is not missing education. But this bill will put her in danger. It will put me in danger. It will put my baby with my new partner in danger. The current provisions of this bill will not increase our safety, and I have no doubt there are hundreds of other mothers in the same position across the country." Chilling indeed. To address this, Amendment 175, introduced in my name, provides the same safeguarding expectations already present in Section 434A, removing the requirement to provide sensitive information where there is a known risk to a child. I'm also concerned about the excessive reporting requirements included in the register, other than the reference to ice creams. While basic information is useful for future planning, Section 436C subsection 1E goes much further, requiring details of all individuals involved and a full list of all activities. This not only places an unrealistic burden on families, but is also impractical for local authorities to manage. And if we break down what's being asked, it would mean that parents must report a neighbour who teaches their child to cook or sew, a local farmer who introduces their children to their environment through hands-on experiences, swimming lessons, museum visits, or even regular nature outings with other home educating families.
Would you accept an intervention?
Of course.
I thank my honourable friend for accepting the intervention. Would she also accept in this vein that As I mentioned, grandparents reading to their children can be considered home education, and they should be inspected and reported upon. But also, vital home education groups that are provided free of charge could be driven out of business by the scale and weight of reporting they'd have to provide.
I thank the Honourable Member for his intervention, and I think a lot of people who don't know anything about home education miss the fact that there is a whole community of home educators. Those children spend plenty of time with their peers. They're just different peers. Other peers that prefer to have their education done outside of a school environment, and there is a risk to those organisations being driven underground or lost altogether. Under Section 7 of the Education Act 1996, parents already have a duty to ensure that their child receives a suitable education, whether through school or otherwise. And local authorities can already conduct informal inquiries and issue school attendance orders if they believe a child is not receiving an appropriate education. So this is just simply overkill. A formal register would help to ensure accountability, but this is an overreach. So my amendment 221 proposes a more practical solution, requiring only those who provide more than 6 hours per week of education or activity to be included in the register, striking a reasonable balance, ensuring that key educators are identified without overwhelming families or local authorities. And while there are genuine safeguarding concerns, local authorities already have the power to intervene under Section 47 of the Children Act 1989, and the Victoria Columbia Foundation actually stated that this act would have done nothing to help Zara Sharif because the local authority had already decided that that child was not at risk. Would you like me to give way?
I'm grateful to the Honourable Lady for giving way. I hope colleagues in the other place will follow up on the Honourable Lady's excellent speech. Focus in on this. If a register, which the Honourable Lady supports, I don't, but if it does go ahead, it should start with the minimum requirements and then could be expanded if needed, rather than this spread out position. And I also, just to reinforce the point she makes, local authorities already have the power to intervene if it appears to them that someone isn't having a suitable education, and has all the powers that is required if there are concerns about welfare. So conflating welfare and education the way this bill does is something which particularly irritates and upsets home educators.
I thank the Right Honourable Gentleman for his intervention. In fact, Catherine from my constituency wrote me a very long email talking about welfare versus this, two totally separate issues, and they're really upset, and they would have been devastated and distraught to hear the member from Morecambe and Lonsdale effectively make them feel like they were some sort of pariahs. I was really upset to hear that, especially as I did ask my home educators to listen to this debate and give me their feedback. I also want to support the amendments submitted by the Honourable Member for Sevenoaks, Amendments 195 and 197, seeking clarity that educational activities outside of regular school terms should not be subject to this overreach. My children aren't subject to them. Children in home education should not be subjected to anything more than the rest of us. And those children receiving education out of school should have the same rights to take their public examinations as their peers. It should not be based upon a parent's ability to fund this. After all, the Treasury is already saving many thousands for every child who is home educated, so this token of support to parents covered under New Clause 53, submitted by my friend the Honourable Member for Twickenham, providing a child to sit any relevant examination and to be fully funded where requested. I do want to thank the Minister for her confirmation. As I sat here this afternoon, I received a letter to say that the challenges faced by summer-born children are going to now be considered, and I want to pass on the thanks, so I'll save the rest of it for you. I was not going to speak about academies, but as I've sat here for the last several hours, I've received 2 more emails relating to them, in particular concerns about their governance. And whilst I heard the challenge from those on the Conservative benches about the comments from the Honourable Member for Montgomeryshire and Glyndŵr, thank you, about teachers, I cannot tell you how many times I'm getting complaints about the way staff and whistleblowers are being treated in multi-academy trusts. Whilst I've sat here today, I have heard of another been suspended by a multi-academy trust. This isn't about them getting better treatment, it's about them getting worse treatment. And if the teachers are being treated badly and they're leaving the sector, that impacts on our children. So it is about the children, not just about the teachers. In summary, whilst I support the principles of the bill, I urge the government to consider the amendments about excessive and potentially harmful requirements imposed on home educating children. They're common sense amendments and they do allow children to be protected without placing undue burdens on families.